Ladies and gentlemen, so that we keep to schedule, maybe we could be seated and get started. I'm Laurel Evans, a program lawyer for the Law Society. I would like to take this opportunity to thank everyone who is participating in this program. All of our faculty, not everyone of whom is available or present at this time for the time that they've taken in preparing their papers. I will not go through the administrative announcements that you had to listen to this morning, since most of you are here for the full day. I will, though, remind you, please, that we have a new set of evaluation forms in this binder, and it's a separate program, so we'd appreciate your taking the evaluation forms out and completing them at your leisure. I'd also like to remind you about the articling student placement forms, which are available on the registration desk. They're the pink forms out there. And for those of you who are media people who may be attending for the afternoon session, we have set up a meeting room which is located directly behind the exit door through the back of this lecture hall, and you can retire there at break and at the end of the program and interview the speakers should you wish to do so. There is one paper missing from the binder of materials, and that's Susan Ursel's. She's expected here this afternoon, obviously, and she's also expected to bring her paper. You'll be able to pick it up at the registration desk at the end of the program. So all of that said, what I would like to do is introduce you to the chairs of this afternoon's program. I'll start with Sari Springer. She is practicing with the firm of Castlesbrock and Blackwell, and since her call to the Ontario Bar, she has been practicing exclusively in the area of labor and employment law. She has prepared numerous legal opinions related to labor and employment law issues and has appeared before various administrative tribunals and other courts concerning these matters. Mr. John Page is a partner in the law firm of Castlesbrock and Blackwell. He advises and represents both private and public sector clients in the areas of labor and employment matters. Mr. Page's special areas of expertise include constitutional litigation, human rights, and regulatory matters affecting corporations doing business in Ontario. He has acted as counsel in several important matters before both administrative tribunals and the courts, including cases dealing with mandatory retirement, systemic discrimination, sexual harassment, and constitutional issues involving the prosecution of regulatory offenses. All of that said, I'd like to turn the program over to John and Sari.
Again, thank you for coming. Sari and I were sitting in our office one day trying to figure out how to advise an employer in a particular situation dealing with the issues that we're going to talk about today, and determined rather rapidly that there wasn't exactly a place that one could go to where this material would be gathered together and easily put one's hands on. It had been coming up in our practices, not all the time, but frequently enough to realize that there was going to be a need to start gathering the information and the cases and the literature and the articles that we're developing, but surprisingly enough, we found very little material that we could quickly put our hands on to help. I guess that was the motivation behind asking the Law Society to put this together. That being said, we have really gathered a group of outstanding thinkers, writers, and doers in the area of sexual orientation and the law here today. Sari and I will take some of the credit for that, but also the persons working at the Law Society can take a good deal of credit, as can the panel or the speakers who got together and identified people. So I think we're in for a very interesting and excellent afternoon of learning and discussing and dealing with these issues. Obviously, it's quite topical now, having gone through a rather quite active and somewhat controversial political path in the last month here in Ontario. Our panel at the end of the day will deal with that issue and the aftermath of the bill not passing. We don't purport to cover all the areas that one might deal with in advising in this area. We have basically blocked it off into areas of law that we thought could be compartmentalized, analyzed, and reported on. It is by no means exhaustive, and there will be obviously other areas where issues are going to arise that we're not going to touch. I think from the bar's perspective in this area, it's critical, and I think that certainly the members of the panel will emphasize this, and we should all strive at advising and working this area, that we do take a principled approach to these issues. They are very important issues, and advising and giving opinions, making sure that we understand not only the practical legal context that we're giving the advice in, but the broader social context of the issues that arise in these areas. And for that reason, I think today we'll hopefully all get a good solid grounding that will allow us to take that principled approach to giving advice and problem solving in the area, and move on to what I think we all see as a very interesting and developing area of the law in the next several years. That having been said, I'm not going to cut into David's time any longer, because he certainly has a lot more relevant things to say about this than I. We're fortunate to have as our lead speaker today David Corbett of the firm of Torrey. David's a litigation partner at Torrey's, and he's also on the faculty of Osgoode Hall Law School, and teaches in the area of negotiation skills, trial and appellate advocacy, and construction law. I think David's active interest in the law comes about from his role as acting as counsel in equality rights litigation, and David has been quite active in that area, representing public advocacy groups including the Canadian AIDS Society, the Canadian Mental Health Association, the Metropolitan Community Church of Toronto, and the Coalition for Lesbian and Gay Rights in Ontario. Without further introduction, I'm going to turn the program over to David, who will speak to us about the historical and social context of lesbian and gay rights in Ontario.
Thank you, John. I'm not going to spend a lot of time on pleasantries because I have an enormous amount of material I'm going to try to cover in half an hour. And I would like to start simply by saying that the issue of civil rights for lesbians and gays in Canada is a civil rights issue prior to being a political or a social issue. The thesis of the paper that I am presenting today is that given the historical background and scientific research and the social development that has occurred over the course of the last 100 years, it is absolutely disgraceful that there has not been complete and full recognition of lesbian and gay rights in this country, and that the faster the courts or the legislatures act to redress this wrong, the closer we will be to saying that we have a society which respects difference and has respect for the principles of equality which are ingrained in our Constitution. My paper is numbered starting at page A1. I am going to go through it and annotate it. And I say at the beginning that it is a very preliminary piece of work. I have given you what I can give you today. It's a vast topic, and I'm going to cover the points that I think I can comment on with some certainty and indicate to you the areas where further work needs to be done. The underlying thesis of the paper I'm presenting today is that over the course of the last 100 years, scientific and political inquiry has moved us from a position where the dominant majority group in society had a clear vision of what was right, what was proper, what was natural, and what inhered in their vision of a community, to a position where our society believes in and celebrates diversity and needs reasons and evidence in order to draw the sorts of distinctions that still inhere in our law today. Let me take you to page 7 And we'll start with some deep, dark history. And I don't purport to be expert in this area. I've merely read the learned work of others. But same-sex sexuality is ubiquitous. It's very clear from the research that has been conducted that it has existed at all times in all human societies. The expressions of that sexuality have varied, the social constructs that surround it have varied, but the inbred desire, which is manifest in the conduct, appears clearly to have existed in all of these societies. And it also exists in the animal kingdom. Now, these are important points when we come to consider some of the objections which are raised by opponents to civil rights for lesbians and gays, and I'm going to deal with that in the latter half of my paper. Starting at page A7, I've indicated the research that's done, and it's collected in a book by David Greenberg, which is an enormous tome, and indicates the prevalence of this conduct and the underlying desire which leads to this conduct in Aboriginal peoples, and in fact he carries it through many different societies. And if you want to see the evidence that establishes this basic proposition, go to his book and take a look at his evidence. It's not the only book out there, but it's a very compendious source for references that deal with same-sex sexuality amongst Aboriginal peoples and various cultures up to the present. I can take you over to page 8, and there's a brief reference to pre-Christian civilizations. And I don't spend an awful lot of time on it here. It's dealt with later in the paper as well, with the prevalence of same-sex sexuality in ancient Greece and Rome. I merely note that there are an awful lot of other pre-Christian civilizations, and I again refer you to Greenberg if you have any doubt as to whether or not same-sex sexuality was present in those civilizations. Starting on page 9, I deal with the Christian tradition in describing it. And really, I don't spend very long on it because to anybody who has listened to the debate or has grown up in our society, it is not news to you that Christianity has been hostile to same-sex sexuality. That's an understatement. And the history of it in our society starts at page 10, and I'm going to go through this a lot more slowly. Up until the 19th century, the law did not recognize gay people as a category. There were acts which were called sodomy or indecent acts, and the person who engaged in those acts was a criminal. There wasn't a whole lot of inquiry that went into the motivation behind the crime. It wasn't until the 19th century that there was any real consideration of what the motivation was for that behavior. And I'm going to come to that when I deal with the history of scientific inquiry. In the English law, on which our law has been based, there was no civil proscription against same-sex sexuality until 1533, when Henry VIII decided it was about time he cast his baleful eye upon it. This, of course, corresponds with a fusion of the church and state in the United Kingdom when Henry VIII broke away from Rome. And the law went back and forth over the course of the following several decades, but finally settled on the original prescription which Henry VIII had devised. And it remained in that position up until 1967 in the United Kingdom and 1969 in Canada. There were variations in the penalty which started to arise in the 19th century, but the law basically was unchanged since 1533 and Henry's original statute. And if you take a look at the law, and the text of it is set out on pages A10 to A11, this is the basis of the law against same-sex sexuality for roughly 440 years. It's referred to as buggery, and it's committed with mankind or beast. And as the law was developed after that, relying on biblical authority, the proscription came to mean between man and man, or between either man and woman or beast. There was no prescription in the English law against anal intercourse between a man and a woman. And that remains the law in the United Kingdom. When the law came to be applied and developed, the impact of the commentators on the criminal law in the United Kingdom, particularly Sir Edward Coke, whose work was brought forward right up until the 19th century, is fairly evident. And it led to several problems. What's the difference between buggery and sodomy? He doesn't say. Perhaps they're the same thing. It appears they are. And the lumping together of bestiality and same-sex sexuality, of course, in the eyes of the general public, did not do a good deal to enhance the reputation of people who like to be with people of the same sex. It's also based on Cook's annotation and reference to Leviticus that we have the exemption of opposite-sex anal intercourse. That was the law up until the 19th century and came into our law in the provinces of Canada, New Brunswick, and Nova Scotia. And I'm now referring on page 14, where the prescription carried a penalty either of death or life imprisonment. It was very, very seriously considered indeed. And after Confederation, the law came into the Canadian Criminal Code in 1892, and it remained intact until 1955, when the penalty was ameliorated somewhat and reduced to 14 years in prison. That was the laws of 1955. Well, what had been happening in the rest of the world? And I take you back to the original comment that I made when I started this, that until the 19th century, it was the act itself which was considered and punished, and there wasn't any great consideration given as to why the person had committed the act. There wasn't any real conception of people who had exclusive or primarily same-sex erotic desire. In the 19th century, scientists started to ask the question, why is there same-sex erotic desire? And I start my discussion of that on page 15. Now today, I suggest to you it's not a proper question to ask. It doesn't matter. People choose to do it or are people born that way. It shouldn't make any difference to their freedom to make that choice. But in the 19th century, this was a very important question because the, not dominant, the overwhelming view of society was that this was very wrong and wicked conduct. And so when that society was confronted by the concept that there were people who were congenitally driven to this behavior, the question why became very important. I note at the beginning of my discussion of this topic that in the ancient world, where this behavior was quite common, people didn't ask the question, why? They didn't even have words to distinguish between same-sex and opposite-sex desire, which is rather odd for Greek society, which was given to distinguishing sexual behavior in a far more variated way than our language does. You know, sending them packing. And also a society which was not merely tolerant, but celebrated same-sex sexuality. The reason, of course, is that in that society, the distinction wasn't important. We go up to the 19th century, and I'm moving ahead now to about page 19. Put the inquiries into context. It's a period of great intellectual ferment, starting out with Adam Smith, who's talking about how the underlying principles of economics were guided by an invisible hand or an objective principle which was external to any particular human society. That was picked up by Thomas Malthus, who applied it to the principles of population growth. And then Charles Darwin advanced the argument further, suggesting that the development of species, including the human species, was based on evolution. And all of a sudden, procreation, which had this divine mission in the Christian faith, for replication of the human species as ordained by God, became a process by which species improved themselves and changed and adapted to their environment, according to scientific rather than religious principles. And this was a very serious challenge to the orthodoxy of the day. Into this context came a man by the name of Karl Heinrich Ulrichs. I'm on page 19 of my paper. And Ulrichs was gay, and he was a strong defender of same-sex sexuality, a position which was a good deal less popular then than it is today. So anybody who thinks they're courageous to stand up and say they're gay and defend that position today should reflect a little bit on what it must have been like for him. And his thinking on the subject inspired others, such as Krafft Ebing, to take a serious look at same-sex sexual attraction. Now, these early inquiries were not what one would call sympathetic. And it's in this period that the genesis of the concept, quote-unquote, homosexuality arose. And that's when the word was coined. It's a 19th century word. It is not an ancient word. And it was coined to describe a pathology that was defined not by scientific observation, but by the religious conclusion which Christianity had maintained for hundreds of years. And what Krafft-Ebing and others of the period set out to do was to explain why it existed and why it was this deviant condition obtained in humankind and what could be done to treat it. As I said earlier, it's not a very scientific portrait of same-sex erotic desire. But it was a significant development in sexology because it identified a different form of desire which was inherent in people, according to Krafft-Ebing and according to Ulrichs. And this was a breakthrough, albeit not sympathetic. Later workers in the area, researchers in the area, notably Magnus Hirschfeld in Germany and Havelock Ellis in England, took the argument further. And Hirschfeld in particular suggested that there was some discrete sex, a third sex of inverts, if you like, which were biologically different from men and women. Again, today this isn't very good science and it's not very good theory, but it was a starting point, the development of a theory that it was natural and biologically driven to have same-sex erotic attraction. This was picked up by Freud, and Freud, of course, is tarred and feathered as having told us that same-sex erotic attachment was the result of some sort of stunted growth in adolescence. And the blighted seeds, he uses these terms, the blighted seeds of heterosexual desire. But Freud was not all hostile to the position of persons with same-sex erotic attraction. And I have in the paper, starting at page 22, set out some of the evidence of his thinking on the subject. And he repeated this thinking quite consistently through the course of his work in the 20s and 30s. On page 22 is a letter he wrote to a woman who had written to him about her son, whose condition she wouldn't actually put into words, but obviously caused her grave concern. And he wrote back effectively saying there's nothing wrong with him because of that. There's not much I can do about it, nor should anyone do anything about it unless your son has some other psychological problem as well. And if you take a look at a public statement that he made as early as 1903, which is on page 23, he concludes it rather emphatically, and the emphasis is in the original, that homosexual persons are not sick, but they also do not belong in a court of law. And Freud was consistently of the view that that was the case, that there was nothing inherently wrong with same-sex sexual attraction, and certainly nothing criminal about it. That was not, however, how the principles of psychology were picked up in the United States of America. And on page 25, I give you a reference to what was a far more common response to the moralistic tradition of psychoanalysis. This is Smith, L.I. Jelliff, who declared that individual training and education should rid homogenic tendencies and direct them to normal, well-adjusted sexual lives. And it's easy to see how this principle is based on an underlying moral conception of what it means to be a human being. It is not based upon, and never was based upon, any objective study of gay persons. It was because of the work of Hirschfeld and Ellis and Freud that further research was undertaken in the face of a consistent moralistic tradition in American psychology. And the most important study in this regard is the Kinsey Report, which is well known by anybody who's studied in this field. And Kinsey was supported financially by the John D. Rockefeller Foundation. And Kinsey himself was appointed to the task because of his unblemished past and his sterling academic credentials. He wasn't a sex researcher before he did this. He was a zoologist specializing in wasps, an irony which I observe but make no more comment on. The research that Kinsey undertook over a period of years in some 11,000 interviews of people was not focused on trying to understand same-sex sexuality. It was supposed to be a portrait of sexual conduct in America immediately following the Second World War. There was no gay agenda to it. And the results that he found, he and his colleagues found, were apparently as much of a surprise to him as they were to anybody else. And it led to the famous statistic that 10% of the population is gay. And Kinsey really made two contributions, two primary contributions to our understanding in this area. I'm going to comment on the 10% figure in a minute, but disregarding the veracity of that figure for the moment, he established that there is a significant minority of people who throughout their lives have same-sex erotic attraction. And this is not some very tiny, discrete minority of monsters living on the fringe of society, but that there are a lot of people like that. And that there are a lot of people who may not have exclusive erotic attraction in that fashion, but who have primary erotic attraction in that way. That was a major shift in understanding and produced quite a reaction, which I'll come to in a moment. The second thing that Kinsey devised was a concept of a sliding scale of erotic attraction. And instead of fixing people into categories of male and female, or male, female, and inverts, if you were following Hirschfeld, he suggested that sexual response followed a range from, on one extreme, exclusive heterosexual attraction to, on the other, exclusive same-sex attraction. And although he devised 7 categories into which he placed people, it's easy to see that this continuum could be subdivided into any number of groups that you might choose to think of. And so he created, and he and his colleagues, well, identified human sexuality as a dynamic force rather than a static concept into which people should be slotted. This, too, was a major change with the tradition up to that point. Well, the Kinsey report fell on America immediately following the Second World War and with the advent of McCarthyism, and was not well received, shall we say. And the responses to it really were twofold and inconsistent. On the one hand, opponents to the existence or acknowledgement of same-sex sexuality denied the statistics and said they were too large. There couldn't be that many perverted monsters running around the United States. And the flip side of it was that those supporting McCarthy took the position that this was simply evidence of the clear and present danger faced by American society as it was infiltrated by so many people who were obviously depraved. And the tension between clear and present danger to insignificant minority has persisted in the attacks by opponents of same-sex rights since that time. Two things happened following Kinsey that I'm going to comment on. First is that in the United Kingdom, Alan Turing was caught in flagrante delicto, so to speak, prosecuted and convicted. Now, Turing, a lot of people don't know who he was. Turing was a brilliant mathematician who was involved in the early development of the computer and was also one of those primarily responsible for cracking the German code during the Second World War. This man wasn't simply an upstanding member of society, he was a hero. And to have him identified as somebody who was supposed to be a depraved monster was a bit of a shock. He was charged in 1952, and instead of being sent to prison, he agreed to undergo hormone treatments, which he did for a year. And about a year after that, he committed suicide. It wasn't the only such sex scandal in the United Kingdom, and it led to the establishment of a committee to study the status of homosexual offenses, as they were then referred to, which is known as the Wolfenden Committee. And it produced a report in 1957. That report does not distance gay and lesbian sexuality from morality. What it does is distance morality from the criminal law. And it says, effectively, that the criminal law has no business governing matters of private conscience. That touched off an intellectual debate between legal thinkers in the 60s known as the Hart-Devlin debate between Lord Devlin and HLA Hart about the proper role of the law, and in particular the proper role of the criminal law, with Hart taking the position that Wolfenden was correct and that the criminal law should not be used for the purpose of enforcing private morality. While this was going on, Evelyn Hooker, who was a psychologist in California, was prevailed upon to start probing the premise that people who were gay or lesbian were pathological. This was an assumption which had been accepted by the community of psychologists throughout the century, which is not a big surprise, because the people these psychologists saw who were gay and lesbian either had presented themselves for treatment on the premise that there was something wrong with them, or had been presented against their will for treatment because they had been apprehended and were involved in the criminal process. And as I comment in the paper, if one were to draw a portrait of heterosexual sexuality based upon interviews from men who believe themselves sexually dysfunctional or who have been imprisoned for sexual reasons, we probably wouldn't have a very sympathetic portrait of particularly heterosexual male sexuality. And that is where the portrait of gay and lesbian sexuality had come from. Hooker was a psychologist, and she was led to this project by an ace student of hers who she didn't initially realize was gay. And when she came to understand this, and he seemed perfectly normal in all other respects, and he said to her, "Look, you really ought to study people like us. Nobody's bothered to go out and assess what gay people are really like unless they're caught up in one of the other institutional struggles, whether that be medical or criminal." And she did that, and she applied to two groups of men, 30 of them heterosexual and 30 of them gay, the same set of personality tests, all of them, which were available at the time. And then she sent them out to leading psychologists in the area who claimed they could identify gay persons by their pathological responses to these tests. And the results came back, and it was very clear that there was just no difference in the test results that could possibly be traced to the sexual orientation of the people involved. There was no consistency of response. And Hooker published these studies in the late 50s and early 60s, and they were directly responsible for ultimately, in 1973, the American Psychological Association dropping what it referred to as homosexuality from its list of pathological disorders. So science and the discussion of the proper role of the criminal law were proceeding along the same route at the same time. And it was at this period, in the 1960s, that the first steps were made to decriminalize consensual sexual relations between members of the same sex. In the United States, it started in 1961 with the draft Illinois Model Penal Code, which started to be picked up by various states. And as of today, roughly half of them have decriminalized that conduct. In the United Kingdom, the decriminalization was 1967, and in Canada, it was 1969. The debates at the time of decriminalization make it quite clear, though, that this was a response and an endorsement of the principle in Wolfenden. John Turner was defending the bill when he was Justice Minister in Canada, and Mr. Turner went to very great lengths to describe the depth of his repugnance for the conduct which was being described. This amendment in the legislative scheme cannot be described in any sense as acceptance. And every parliamentarian on the record who supported this bill was quite clear that what this was the state saying there is a realm of private morality into which we will not go, but we want it to be absolutely clear that on a personal level we find this conduct immoral. That was 1969. What has happened since that time? You're not going to find a lot of detail about this in the paper because I think it's dealt with by some of the other speakers later. But since 1969 and Stonewall, the riots in New York City and the gay activism which has arisen from that, is that the focus of equality rights has moved from a concept of tolerance to a concept of acceptance. And when we hear the debates on television and when we listen to the opponents of extending civil rights to same-sex couples, they draw a distinction between tolerance and acceptance and indicate that they are prepared to tolerate, but they are not prepared to accept. In my respectful view, Section 15 of the Charter cannot now be interpreted to mean bare tolerance. It is not how we mean it when we apply it to other minorities which are protected by it, and that acceptance is what the law requires. I'm not going to spend a great deal of time on the state of the law now because it is dealt with in the other papers, but I simply direct you to pages 34 and 35 of my paper where I've set out the general thread of the law and how it is developed. What I'd like to do instead of talking about that is to address some of the objections which are raised to extending same-sex recognition, both individually and to couples. And these are taken directly from the debates which have just taken place with respect to Bill 167. And I start this at page 37. And these arguments really all and always boil down to the same three arguments, if you parse them carefully enough. First of all, that same-sex sexuality is immoral. Secondly, that it is unnatural. And third, that it's contrary to religious teaching or God's law. And I'm going to comment on some of what I refer to as the sub-arguments as I go along. But the basic thesis of what I am saying here is that to rebut a legal claim to entitlement to civil rights, rhetoric isn't enough. Simple, naked value judgment isn't enough. There must be principled reasons for denying rights, and these reasons must be supported by evidence. And in my respectful submission in the recent debate, that was notably lacking. First objection, which I'll deal with, is that the allegation that same-sex sexuality is immoral. Now, there are two ways that this argument can be invoked. One is to deny same-sex sexuality any recognition at all, including tolerance. That isn't raised very much anymore, now that the dam has burst, so to speak. But what does it mean when it's applied for the purpose of limiting recognition? And I've set out my views of the various alternatives that it could mean, starting at the bottom of page 37. Now, the first argument, what is meant by immoral, is that it is, to some people, unnatural, revolting, an aberration, or an illness. And I'm going to deal with that as a second objection, the suggestion that it's in some sense unnatural. The second is that it's contrary to religious teaching or God's law. And I do want to make a comment about that before dealing with it as a separate ground later on. In my respectful submission, this is not a proper basis for asserting a moral claim in a secular state. We're not run by any particular church. And simply saying that the dogma of one church or another sports a particular view is not authority in our courts for denying rights. If it were, it would be authority for denying the rights of other religious groups as well. I can't find any authority since the Charter was enacted for the proposition that because a moral postulate occurs in the Bible or any other religious document, that it is binding on anybody. Must remember that we're talking here about the law. When we're talking about morality under the law, we are talking about public morality, state-enforced morality, and invoking religion for the purpose of justifying some sort of restriction on recognition or behavior. We are fusing the state and the church, which is a very, very dangerous thing to do. We again come back to the idea of distinguishing between private and public morality, and I suggest that we really ought to have got beyond this with the Wolfenden Report and its acceptance. A third ground of objection is that accepting and recognizing same-sex sexuality will undermine the family, and that this is immoral. As a matter of social policy, this is an important and complex issue. What do we mean by a family? And this is a question which has concerned courts in a number of cases, and I'm going to just make a brief comment on it now, particularly in reference to the marriage cases. Our courts have avoided analyzing the substance of the issue about whether same-sex couples should be permitted to marry by applying definitions. The historic definition of marriage, going back to the 19th century and indeed back further than that, is, quote, a union between one man and one woman, unquote. Is that what anybody really means by marriage anymore? It's a pretty meager definition. It doesn't say anything about love, doesn't say anything about commitment, doesn't say anything about independent legal personality of the two who have been joined in the union. It would apply just as well to the 19th century conception of women as subordinate to their husbands with limited property rights. In fact, it would apply perfectly well to a society that said its men owned their wives. That's a union. And it says nothing about the companionate nature of the relationship or the support between the people who are in it. On what basis, then, is it a principled reason for denying marriage to same-sex couples? And the answer is that it isn't. It's simply taking a historic definition, noting that it excludes the current claim, and winding up the debate and suggesting that same-sex couples must be some other kind of animal simply because they are defined as such. That's not an answer. When we hear people say the claims of same-sex couples stand as a threat to family values or the family, the only response has to be, why? On what basis do you say this? What evidence do you have that this is so? Can you show us that in Denmark the family has collapsed as an institution because of the recognition of gay couples? The answer is no. Can you show me any society where it has happened, where that has happened? The answer, again, is no. These claims, to be sustainable in a court, must have evidence behind them. And I suggest to you there just simply isn't that evidence. To the claim or the objection that same-sex sexuality is unnatural, and this is one that came up most prominently in comments by George Mammoliti, an NDP member of the House, and in a television debate or discussion on CTV, which was aired coast to coast, where Tom Wappel said that anybody who was gay or lesbian was unnatural. And that's hate speech, in my respectful view. What's meant by unnatural? Revolting, disgusting, vile? We might describe infanticide or slavery in that fashion. Is it some unfortunate deviation from the norm? That's how, as I suggested in my paper, we might describe two-headed calves or Siamese twins. Suggesting that these comments or labels are not in some sense derogatory or do not suggest that the people against whom they are applied are inferior is to deprive the comments of any content at all. The courts of our country have now consistently said in Section 15 jurisprudence that sexual orientation is protected under the Charter. It's consistent. It really is consistent all the way through. And the only barrier to being able to say that this is clearly the law of Canada is that the Supreme Court of Canada has not yet had an opportunity to say so, and with any luck, it will do so in the Egan case sometime in the next year or so. If that is the case, then persons who are gay and lesbian are entitled as a matter of law in this country to equally deserving of the concern, care, and respect of the legislatures, to be treated in that fashion. And that is wholly inconsistent with a judgment which brands gay and lesbian people as inferior. It's wholly inconsistent with treating them in an inferior or substantively different way under our laws. In manner of conclusion, I'd suggest to you, ladies and gentlemen, that the record of the history, both the science and the ethical discussion from the 19th century to the present, shows a consistent movement towards a recognition that being gay or lesbian is simply a matter of being different than being heterosexual. And that as a matter of law, under our Charter and our principles of equality, it is not right for our legislatures to be discriminating in the laws that are applied to them. Thank you.
Thank you, David. That was an excellent and extremely informative speech. I'm sure you may have some questions, although we're going to hold off so that we don't get too far behind schedule, if you don't mind. And I'm sure David will be happy to answer any questions at the end. Our next speaker is Peter Jervis, Mr. Jervis practices law with the law firm of Lerner and Associates. He was called to the bar in 1983 and worked with the Constitutional Law Division of the Ontario Ministry of the AG for a year, specializing in constitutional and charter litigation. Since then, he's been involved in constitutional cases at all levels, including the Supreme Court of Canada. He has lectured and written on the topic of the Canadian Constitution and the Charter of Rights, and has acted as counsel for a number of public justice organizations. I now introduce Peter Jervis, and he will speak to you about the application of the Charter.
Thanks very much. Excuse me. I can't hope to cover the same scope of history as David has, partly because he knows a lot more about history than I do, and partly because, fortunately for me, the Charter only arrived in '82, and therefore the issue of how the law has been held up to constitutional scrutiny under the Charter is a new concept, which is very exciting for us because, of course, as we all know, who are involved in charter litigation or who are academics commenting on this, or those that follow the cases, is that the law is being developed and rewritten in our time, and indeed the principles which are being established now are crystallizing into a body of law which will form the basis for this society for, I believe, many generations to come. So we really are living in exciting times, and as one can see, there have been very rapid developments in many areas of the Charter, and specifically with respect to the area of sexual orientation in the law, or one might say the failure of the law to recognize and give fair application to the issue of sexual orientation. I should say at the outset, there's a paper that's in your materials, and I was greatly assisted, and that's putting it mildly, in the preparation of the paper by a lawyer in our office named Lisa Monroe, who's here today, and I thought that credit should go to her for a lot of the work that was done in preparing the paper. One of the things that's clear in preparing a paper and giving a talk on this subject matter is that no paper can truly be a compendium of the law with respect to sexual orientation, because there's so many cases. A lot of the cases are at lower level courts, and we really are getting to the key area right now. And as David said, the Egan case, which I understand is going to be argued in the Supreme Court of Canada either this fall or early in the winter term, is going to go a long way to establishing the direction of the law. Although, as you read the cases, I think you can see the direction that the law is going. And what I'd like to do is to comment on some of the directions that I see the law going, and just some of the key cases. And I've in the paper there's a discussion of the Section 15 jurisprudence and a number of the cases. What I'd like to focus on are the general Section 15 principles that have been applied in considering the issue of sexual orientation of the law, as I phrase it, or as the people who titled this presentation phrased it. And those really derive from the Andrews case. Those of you that have read Andrews and the Law Society of BC ad nauseum, I hope I don't put you to sleep, but I think it's extremely important to understand what Andrews said, and to, as supplemented by Turpin, because there's a real, I think, confusion in the application of those principles in the sexual orientation cases. And then there are a couple of key cases that I'd like to talk about, and those cases are Hague. And clearly Hague has got to be the leading case right now. That's a decision of our Court of Appeal, and I'm sure you're all familiar with it. Hague, and then Mossop in the Supreme Court of Canada. And then the two cases right now that are on the agenda, I think the leading cases, Leyland and Egan. There are other cases that are percolating through the system, but I think Leyland and Egan are the ones that may establish the crystallization of principles that will determine many of the other cases. One thing which is clear when you read the law, and David touched on this, well, not more than touched on it, talked about it clearly. There's a huge ideological struggle going on. I mean, anybody that followed the Bill 167 debate in the legislature, I mean, people can talk about the fact that, you know, the government approached it this way and they should have done it that way, or they didn't reach a political compromise soon enough, blah, blah, blah. But the reality is that there was a huge ideological struggle as well as crass politics going on. In the courts, there's an ideological struggle. And as is clear with the application of the Section 15 principles, I think Leyland is the best example of it. You can see that they're just combating ideology. People take the principles and because of an underlying framework, apply them this way or that way. And they either say there's inequality or there isn't inequality. A lot of the arguments are circular. Quite frankly, I don't think that there's logical consistency in a lot of the arguments. If I were a judge, perhaps I'd be struggling too to apply those principles. But I think it's clear that this is an ideological battle which we're confronting. And there are arguments on both sides which are firmly held in one's view of what is good and just and fair, et cetera, et cetera. If you look at the case law, quite frankly, it appears that if one is applying the principles in a logically consistent way, it seems to be driving towards a clear statement in the law that Section 15 requires equality of application without distinction between heterosexual or homosexual unions, or without exception or distinction between who is capable of receiving benefits in the benefits cases or the marriage cases. And my view is that the law is driving inexorably towards a redefinition which will change the traditional analysis of family units, marriage, spousal status, etc. That's what's going to be decided in the courts, but it appears to be the momentum. It appears that the momentum is going in that direction. Now, starting off with the Andrews principles, and just before I get to that, I should say this. Section 7 doesn't really appear to have been argued in the case law, and perhaps it won't have to be after Egan and Leyland are decided, building on what was established in Hague. However, I do think that there are some Section 7 arguments. Those of you that have read the Morgenthaler case know that what the court did there was say, we have a law which is substantively unfair and which is causing huge psychological burden to people. There is not access to something which is, in that case, medically necessary. But what the court did was use Section 7 to tear down some distinctions in the law. In that case, you could get an abortion in some places, you couldn't get an abortion in other places. All I say is that for those of you that may be arguing these cases, it may be that a Section 7 argument might have some usefulness in some of the contexts. I won't say anything more than that, except to say that the case law appears to have ignored Section 7. Section 15 is the key battleground, and anybody who's studied 15 knows that they have to go to the Andrews case, and that's Andrews and the Law Society of British Columbia. And in the paper, Andrews is discussed from pages 6 to 11, and I don't intend to read the paper to you, but in applying the equality jurisprudence, question number one is, does the law identify distinction or make distinctions? Well, stopping there, it's probably a ridiculous question because virtually every law makes distinctions or draws distinctions. Those that are speeding, going above 60K, and those going less than 60K, et cetera, et cetera. What Andrews says is that the issue for equality jurisprudence is a distinction drawn on the basis of irrelevant personal characteristics. And if you look at the top of page 7 in the paper, there's a quotation from Justice McIntyre's decision in Andrews which sets that out quite clearly. And at the bottom of the quotation, the last sentence reads, in other words, the admittedly unattainable ideal, that's the ideal of equality, should be that a law expressed to bind all should not, because of irrelevant personal differences, have a more burdensome or less beneficial impact on one than another. So the question number one in this analysis is, does it draw a distinction, and is that distinction based on irrelevant personal characteristics as opposed to relevant ones, such as people that are speeding and people that aren't? In Andrew's case, you couldn't be a lawyer if you were a non-citizen. Well, that drew a distinction based on an irrelevant characteristic. Whether you were a citizen or not, it wasn't determinative of whether you're going to be a good lawyer. Similarly, one would say a law which says people can be married only if they satisfy the common law definition, which excludes same-sex partners, draws an irrelevant characteristic. Now, that's the issue in Leyland. Point number 2 to establish an equality claim is whether or not the personal characteristics are sufficiently immutable that they are similar to one of the enumerated grounds or constitute one of the enumerated grounds. Obviously, with respect to the issue of sexual orientation, we're not dealing with one of the enumerated grounds. Now, I can stop right here and say that although the Supreme Court of Canada hasn't said so yet, there isn't much doubt that in the Egan case, the Supreme Court will say clearly, and one would suspect unanimously, that sexual orientation is an analogous ground. The Court of Appeal said that. Justice Creever said that in Hague. The Divisional Court said that in Leyland. The Federal Court of Appeal has said it in both Vasey and in Egan and in Nodal and other cases. So it appears clear that sexual orientation is an analogous ground. So then we get to the third component of an equality claim. And the third component is the distinction which is drawn, the invidious or unacceptable distinction, is it one which discriminates? Is it one which imposes a burden or denies a benefit? Now, that's not the end of the question, but clearly there can be distinctions which don't impose burdens. I find it difficult to think of them, or don't deprive benefits or advantages. I find it difficult to think of one. And so if one stops there, and by the way, I should say, if you look at page 7 of the paper, the classic expression of what I've just said from Justice McIntyre reasons is found at the bottom of page 7 of the paper and the top of page 8. And this is Justice McIntyre and Andrews. And perhaps I should just read it to you because it says it clearly. A distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group. So that's the distinction component. 2, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others, or which withholds or limits access to opportunities, benefits, or disadvantages available to other members of society, is prohibited discrimination. And then he goes on to say, distinctions based on personal characteristics attributed to an individual solely on the basis of association with a group will rarely escape the charge of discrimination, while those based on an individual's merits or capabilities will rarely be so classed. So stopping there, in a case which is dealing with sexual orientation, if one says there's a distinction based on sexual orientation which denies a benefit such as marriage or denies spousal benefits such as Egan, pension benefits, then one would prima facie say there's discrimination subject to the application of Section 1 of the Charter. But stop there, because the court went on in Turpin to say something more. And the something more that it says, in my view, creates a lot of ambiguity in the Section 15 jurisprudence, which can determine the outcome of cases. I'd like to read that to you, if I can find my copy of Leyland. The passage is quoted in Leyland, and when I talk about Leyland, I'll come back to the passage. I'll come back to this again, but in Turpin was another equality case, and Madam Justice Wilson said in Turpin that after you've considered distinction and imposing invidious burden, you then look at the larger social, political, and legal context. She wrote, it is important to look not only at the impugned legislation which has created a distinction that violates the right to equality, but also to the larger social, political, and legal context. And then she goes on to say, accordingly, it is only by examining the larger context a court can determine whether differential treatment exists in equality or whether, contrariwise, it would be identical treatment which would in a particular context result in inequality or foster disadvantage. And she goes on. That's page 664 in Leyland. I didn't give you the site in the paper, but that's 14 OR 3rd. Now, stopping there, what the court says is you go through the technical analysis and then you stand back and look at the larger context. This was used in Leyland by both the majority and by Justice Greer in dissent to reach opposite conclusions. So it appears to introduce a certain degree of arbitrariness in the analysis. And I think it can be used by people in these types of charter cases to assist their case, but it's also been used by people opposing the extension of Section 15 to deny it. The example in Leyland was this. Those of you that are familiar with Leyland, two gay men who'd been living together for 20 years and owned a home, went to the, I believe it was 20 years, went to the city hall and said, we'd like a marriage certificate. And they said, you can't, because at common law you can't be married. Application for judicial review to the divisional court, and the issue was, does the common law definition of marriage or common law with respect to marriage violate the charter? And the majority said, no, it doesn't, because anybody who doesn't fit within the, anybody who can't get married are not discriminated against on the basis of their sexual orientation, because indeed, people who are homosexual can get married if they want to. They just have to get married to someone of the opposite sex. So the distinction here is based on those that choose to get married to procreate and those that don't. Homosexuality has nothing to do with it. And they say, let's look at the larger political context. The larger social and political context is that marriage is for procreation. Homosexuals can't procreate. Of course, that ignores new technologies, and it ignores the reality that a number of gay or lesbians may have children from previous relationships living with them. But they simply say homosexuals can't procreate, and looking at this larger analysis, clearly the purpose of marriage is to permit procreation. And we look back in the history of Christendom for that, and they relied upon some old case law, and the type that David was talking about, the type of case law that arose earlier in this century. So therefore, the larger context means that notwithstanding that technically the Section 15 analysis clearly says that the common law definition of marriage would appear to discriminate, we say that it doesn't. Madam Justice Greer cited exactly the same passage from Turpin and said, let's look at the history of discrimination against gays and lesbians in our culture. Let's look at the history of suffering. Let's look at the history of invidious discrimination. Clearly, and also let's look at the evidence which shows that there are a number of gay or lesbian partnerships which are like families, and surely the common law must evolve. So she used that same fourth component of equality to say that Section 15 must clearly apply here, and clearly the definition of marriage at common law must be unconstitutional, and therefore granted a declaration. So you have the same principles being applied by the majority in one way and by Justice Greer in another way. Exactly the same thing happened in Egan, and I'm kind of rushing here because I'm running out of time. But in the Egan case, the case dealt with the definition of spousal status in the Old Age Security Act. Egan and his partner, I believe his name was Nesbitt, if I'm not mistaken, had lived together since 1948. Evidence was filed showing that they had all of the, that their relationship was similar to a heterosexual relationship. One of them reached 65 and the other applied for spousal benefits. The majority judges said, and the issue was, does the definition of spouse discriminate because it excludes same-sex partnerships? Or put it another way, it only includes people of the opposite sex. Only people of the opposite sex can be a spouse. And the court applied exactly the same principles. This was the Federal Court of Appeal and the Federal Court Trial Division, as did the court in Leyland. And what the court concluded there was that the majority, two judges, Robertson and I believe it was Mahoney, said, obviously, the purpose of the definition of spouse, historically, we're talking about procreation and we're talking about traditional units. In this case, non-spousal status is the distinction. There are those that have non-spousal status and those that have spousal status, and if you have non-spousal status, you can have it for a variety of reasons. It's not necessarily determined by homosexuality. There are other people that live together but aren't spouses. And therefore, the distinction here is not between heterosexuals and homosexuals. The distinction is between heterosexuals who can marry and everybody else who hasn't married. And what the court said in that case is the distinction here is not based on sexual orientation. The distinction is based on spousal status. Now, stopping there, obviously one can see the circularity of that argument and the conclusory nature of the argument. One could say, of course I would never say this about a judge of the Federal Court of Appeal, but one could say that there was a certain lack of intellectual rigor in the application of those principles. If one looks at Justice Linden's dissent, Justice Linden says clearly a law that says that you can be a spouse if you're of the opposite sex, but not if you're of the same sex, is clearly directed to excluding people who want to have relationships who are of the same sex. Clearly, it's directed to sexual orientation, which is a prohibited, which is an analogous ground, and clearly it imposes a burden. And if you look at the larger social and political context and the history of discrimination against gays and lesbians, you have the application of Section 15. The two judges in the majority said that isn't the case. And they used the same principles, perhaps somewhat loosely applied, to justify essentially the argument that the purpose of family units is to procreate, and the purpose of spousal status is to protect people who traditionally have been spouses. So there you have in Egan a situation similar to what you have in Leyland. Now both of those cases are going on appeal, Leyland to the Court of Appeal, Egan to the Supreme Court of Canada. And it appears clear that the Supreme Court of Canada is ready to get its teeth into Egan. And that can be indicated by the Mossop case. And those of you that have read Mossop will know that in that case, Mossop was a federal civil servant who was denied bereavement leave when his gay partner's father died. And he wanted to go to the funeral. And they said, well, you can't go to the funeral because this is not a family member of a spouse, I think was the way it was defined. And so he went to the Canadian Human Rights Commission and said, I'm being denied, I'm being discriminated against. The issue there, it was not a charter challenge to the Canadian Human Rights Act. It was simply a decision of whether he was being discriminated against on the basis of family status. And the case went all the way to the Supreme Court of Canada on the issue of whether or not this was discrimination because of family status. Now, what the court had to do was interpret the term family status. Was this an ambiguous term which should include both heterosexual and homosexual couples, or was this clearly intended by Parliament only to include heterosexual couples? And the majority of the judges, 4-3, said only heterosexual. However, they went at pains to say, we're not dealing with a charter issue here, we're not dealing with an attack to the Canadian Human Rights Act, which clearly excludes sexual orientation as a ground of discrimination, and we're not deciding whether or not these people are being discriminated against because of sexual orientation. Rather, it was definition of family. The court made it clear that if the issue did come to them as a charter attack on the Canadian Human Rights Act, they might have a totally different approach. Now, what's happening in Egan is it's not an attack on the Act, but it's an attack on the same concept, which is a limitative definition of spouse. Now, one further interesting aspect of the Mossop case was that in that case the court had to decide what a family was, and there was two different views: the traditional concept of family and the reason for that traditional definition of family, and the more functional definition of family, which is the kind that Alan Rock is talking about, that was being proposed by Marion Boyd in her last-minute attempted amendments to Bill 167. Justice LaRue Bay proposed a functional definition of family, which could have great application in the other cases. Now, that's dealt with in the paper, and I won't say any more about it than that. I think I'm run out of time, but if I can just comment briefly on the Hague case. Hague was the decision of the Ontario Court of Appeal in 1992, which determined that the provisions of the Canadian Human Rights Act were unconstitutional because sexual orientation was not a prohibited ground. Hague was an officer in the Canadian military, and when he declared that he was gay, he was told that he couldn't be promoted and he couldn't be transferred, and essentially he was going to be dead-ended. And so he said that this was unconstitutional. The Court of Appeal agreed with him, and Justice Creever applied the Andrews principles that I set out, the four principles, in an intellectually coherent way. His reasoning has been adopted in subsequent cases and is the leading decision right now under the Charter, as far as I'm concerned. And what he said was, clearly, you look for a distinction. Here, you have an act which clearly excludes a class based on a personal characteristic, sexual orientation. Clearly, it's an analogous ground. Clearly, it imposes a burden and denies an advantage, since people who are discriminated against on this basis do not have the benefit of the legislation. But then he said, let's take the Turpin analysis and let's look at the larger historical picture. And he relied upon considerable evidence of the historic position of gays and lesbians in our society and culture, the discrimination, the humiliation, the difficulty, et cetera, et cetera. What he said is that clearly this shows that this is a group that deserving of the protection of Section 15 of the Charter. That case, and there was no defense offered under Section 1, and we don't have time to talk about Section 1, but I do believe that a lot of these cases may turn to Section 1 now after Egan, Hague, and Leyland. I think that a lot of the future groundwork will be in Section 1, and potential justifications for distinctions which prima facie are discriminatory, and the court will see whether or not it will find any justifications. One thing I should say, though, is that in the Andrews case, it makes it clear the importance of an evidentiary record in cases like these, because if an evidentiary record is laid of historic discrimination or of a clear record of similarity of relationships, one would have to look at the case to determine the evidence that was necessary. But I think that it's important that a really solid evidentiary foundation be laid in these cases. If so, the application of the principles like Creever and Hague or Greer in Leyland or Linden and Egan will be that Section 15 claim will probably be made out. Now, I've had to rush through this. I hope it's been helpful to you, and maybe there'll be some questions.
Thank you very much, Peter. That was a terrific speech. I'm now going to ask Judith Keene to take the podium. She's going to speak on the application of the code. Judith was called to the bar in 1981 and practiced in government for about 8 years. She's published extensively in the area of human rights and administrative law, including the recently completed second edition of Human Rights in Ontario, which I know I use a lot in my practice, and I'm sure you do as well. Judith also serves on the board of Alliance for Employment Equity and is currently with the Clinic Resource Office of the Ontario Legal Aid Plan, providing legal research and litigation strategy advice to 70 legal clinics. Judith?
Thank you. I should say right up front that John and Sari picked the perfect person to talk to you just before the break. It's a serious question whether I can go over the time. I have a little asthma problem. It's bothering me today. The weather's not been favorable to people with asthma. And if I want to make one of these great big gasps in the middle of a sentence, it's not because I've discovered I'm missing a page of my text. I'm going to try to, by the way, keep from reading my, bear with me, I'm sorry about this. I'm going to try to keep from reading my text and just try to strike some of the points that I really want to make here. The first is that I'm assuming that a good number of people in this room will be involved in litigation in which they are claiming that there is discrimination on the ground of sexual orientation, or for that matter, discrimination on other grounds. And a lot of my paper is very general about discrimination, and only the end is specific to discrimination on the ground of sexual orientation. Obviously, the principles are very much the same. And the thing that I would suggest to anyone who is in the course of litigation is, never mind the course, before you start, is to have a theory, an enunciatable theory about what is happening to your client, why it is happening to your client, and who is responsible or what is responsible. In short, a theory of discrimination, of why this is discrimination. Sorry, this is rather basic, but it's also absolutely fundamental. Among other things, the what's happening is going to give you some clues as to whether you need to do research having to do with the type of discrimination that involves differentiation, or the, quote, adverse effect type of discrimination. The why it is happening will clue you in advance as to whether you're going to have any problems establishing that your client is being discriminated against on a ground that's covered in the code or in Section 15 of the Charter, or whether in respect of Section 15 you have to frolic into the unenumerated grounds and prove that this is an unenumerated ground and ought to be included under Section 15. And what was the third one? Oh yes, who. The who or what is responsible, of course, feeds you your clue. about whether you can use the Charter of Rights in this situation. So, you know, obviously, if it's a private action and a private action only, you're out of luck on the Charter. Now then, the other thing that I should do is just a few words in advance about discrimination and equal treatment. It's funny, for those of us who have followed human rights legislation for years and years, because it's been in place for 30 years, certainly in Ontario, we have these lines of cases that have developed under human rights legislation. And nobody really has much of a definition of discrimination or a definition of equal. But you read the cases and you make your way along, and you know, it's coming it's coming together, it's coming into place. Contrast section 15 of the Charter. The word discrimination is used, the word equal is used, but certainly at the higher court level, at the Supreme Court of Canada level, we have precious little to go on. And predictably, in a relatively new area of law, we have this period of time which we're suffering through now, in which things are all over the map about what's discrimination, what's equal, and all that sort of thing. And if I can just nutshell it informally, a review of the cases under the Charter of Rights shows the courts having trouble maybe on 3 specific areas. First of all, this is not a problem. What is bugging your client is not worth considering discrimination. That hasn't happened a whole lot in the courts under Section 15. Sometimes it has, but rarely. It's happened a bit in human rights jurisprudence, mostly in areas in which the practice in question is entrenched and normal. And I'm speaking of things like women working in bars having to wear your basic Playboy bunny outfit. You know what I mean? You notice that the men servers do not have the tails, the ears, or the little number. And human rights tribunals have had trouble, and the courts have also had trouble, suggesting that this in fact is a problem worthy of consideration. You know, one does sort of tend to want to suggest to their honors that they try it on for size, but that is unthinkable. But as I say, it rarely happens in respect to Section 15 of the Charter. The second problem is you have the court effectively saying, well, yeah, it's a problem, but it's not because of a ground prohibited by the legislation or because of a ground listed under Section 15 of the Charter, or indeed an unenumerated ground. It's not because you're female, single, and the mother of a small child. It's because you're poor that you're getting the thin end, short end of the stick, sorry, the thin end of the wedge or whatever on this, that the problem is arising. That's a problem that we have, we've got a big problem of that nature so far with the Supreme Court of Canada jurisprudence, and it's come to a head in the Symes case, which I'm not going to talk about here, but if you read Symes, it's interesting to note, I know that Symes, the theory within Symes is a bit problematical, even for those of us who are very gung-ho on sex discrimination, or indeed on eradicating sex discrimination. It was a bit problematic. It was a tough case. But it's interesting that the same court that decided Andrews and had no difficulty understanding the plight of the poor gentleman who could not be a lawyer because he wasn't a citizen, had real difficulty, at least the majority, in understanding that child care might be a serious problem for a woman professional, and that a lot of mud was thrown at the fact that she was, as people go, a fairly privileged person. So I'll now shut up on Symes because I can't really say anything terribly intelligent about it with the rest that I've got to say. Query whether I've said anything intelligent yet. Okay, now the third. Well, yes, your client has a problem, and yeah, it probably relates to a ground that is forbidden in terms of discrimination under the legislation, or it relates to a ground of discrimination that's under Section 15 of the Charter, but others are just as badly off. That's unfortunately come to a head in the Thibodeau case. There's a little piece of obiter in there that I'm awfully afraid may say that in a sex discrimination case, if your pool of people is contaminated by the presence of a single male, it's not sex discrimination against women because there are others just as badly off. Again, that is a toughie. Again, we're going to have to slug our way through that. And I would suggest that there is a way, but we're going to have to do a great deal of very clever, fundamental, basic advocacy with the courts about the nature of discrimination. We've been so far, certainly with the Supreme Court of Canada, it has not yet done an adverse effect discrimination case. You know the sort of thing I'm talking about, folks. It's relatively easy when you have a case of clear differentiation. No blacks, no women, no gays will be allowed to partake of whatever this is, and the rule is very clear on its face. A clear case of differentiation. Now, most people understand that to be discrimination. And indeed, most definitions of discrimination so far have stressed heavily differentiation, but I submit that that is only because, certainly at the Supreme Court of Canada level, it's all they've had in front of them. And they've been starting to carve new law, and they've been signaling to us madly that they are reluctant to make broad general statements in a new area of law. So I wouldn't be intimidated. I think one must bear in mind that one must stress differentiation where differentiation exists. But one mustn't be intimidated and figure that because there is no differentiation, we're doomed. If you look at human rights jurisprudence, in the tribunals and the courts under human rights legislation, we've advanced in terms of our understanding of discrimination so that something that, as they say, is facially neutral. The classic example given is height and weight requirements for a specific job. And if that obviously excludes groups of people who, by their nature, are not necessarily going to be, most of them aren't going to be 6'2" and 250 pounds. So most women, most persons, for example, of South Asian extraction, obviously there are exceptions, but you'll have, a large number of people. And in the context of human rights legislation, courts and tribunals have grasped this, and the Supreme Court of Canada has grasped this, that adverse effect discrimination does exist, that it doesn't have to be a clear differentiation. Now, we haven't gone so far, however, to really explore what we mean by facially neutral, because lots of things that the majority consider facially neutral are not the slightest bit facially neutral to people who are affected by them. Like, we know who it's blocking. The business, for example, about child care in the Income Tax Act, I doubt there's a woman who thinks that's a facially neutral anything. We're very much associated with child care. So I think that there's a lot of development to be had in the idea of adverse effect discrimination, that discrimination that is not a clear and on its face, a differentiation. I think there's something between facially neutral things and a clear, no blacks rule. That remains to be developed. And I probably better not get into the theory of that because there are other things to cover. Oh, 5 minutes. Okay, going through the paper. My thesis that I try to make in this paper is that we really ought to look, those of us who are looking at the Charter ought to look routinely at human rights jurisprudence as well. And by the way, also ought to consider it our other source, our other area of law under which we challenge discriminatory things. I'll note it's all in the paper, all the cases and so on, and the sections of the Act. For example, in the Ontario Human Rights Code, there is a paramountcy clause. Very few people know this. And it says, essentially, that other provincial legislation that purports to authorize discriminatory behavior can't be upheld insofar as it breaches the code. Not bad. It's almost as good as the Charter, And nobody has made much use of this. But I think if I were dealing with a piece of provincial legislation that had a discriminatory effect, I would plead both the Human Rights Code and the Charter. And knowing that judges tend to be reluctant to deal with the Charter, I'd probably stack it that way, Human Rights Code and Charter. And the advantage of all that, by the way, is that you do have quite a lot of human rights jurisprudence to draw on, much more than Charter Section 15 jurisprudence, and you can fire away with that. Now, there has been, and I've reviewed it in my paper, a little reluctance on the part of courts, an initial reluctance to construe human rights legislation because of a case called Beduria, decided umpteen years ago, in which the Supreme Court of Canada essentially said there is no tort of discrimination. Someone tried to bypass the code and say there was a tort of discrimination and go through the courts directly. The court said, no, you can't do that. There's a statutory scheme set up for you. There's no tort of discrimination. And they went perhaps a little farther and essentially intimated that you couldn't use the courts for human rights matters. But the courts have, well, I think they have distinguished Beduria. Well, if you have to distinguish it, I think you can also construe it that it's not exactly a bar. You don't have a bar to mentioning and arguing human rights legislation in the courts. That you don't have to confine yourself to a tribunal called under the legislation. And I've listed a bunch of cases. They are mostly wrongful dismissal cases in the civil area in which the code has been applied. And I've got all the sites and stuff in there, so I won't trouble you with the cases. And certainly in regard to other tribunals, there's also a list in the article of other tribunals, not tribunals under human rights legislation, who routinely apply the code. Labor relations matters, I gather, they now relatively routinely apply the code and construe, things as discrimination and therefore, I don't know, contrary to the collective agreement or whatever else, but they use the code and they use human rights jurisprudence. And there's some quite interesting jurisprudence on that. And of course, the woman has just stepped in, Susan Ursel, who is going to tell you more about that. Now, in regard to sexual orientation, just to go briefly through it, there are cases under both the federal human rights legislation and the Ontario human rights legislation having to do with sexual orientation. And oh, by the way, of course, it's important to remember that Ontario legislation, the federal legislation doesn't contain sexual orientation specifically within the statute. But it has now been construed by our Court of Appeal, actually, to breach the Charter in not containing sexual orientation within its grounds of discrimination. So as long as that survives challenge, it will effectively have the protection in regard to sexual orientation. That doesn't get us out of the woods for all discrimination matters, but it does for a surprising number, because under the federal and Ontario human rights legislation, we do have the areas of employment, service provision, accommodation, oh dear, rats. Imagine me not remembering the grounds. I'm sorry, accommodation, service provision, employment contracts, and various others. I'll refer you to the code. And we've got, oh, you can read, can't you? And I plead asthma. And we've got, lots of helpful Supreme Court of Canada jurisprudence that directs us to construe human rights legislation broadly, purposively, so don't be afraid to stretch it. So under the federal human rights legislation, we've got an almost situation in the sense that we've got the Court of Appeal saying that you should read in. Under our Ontario legislation, it's already there. The problem with the Ontario legislation has centered on the debate over family status, and specifically insurance policies that exclude same-sex spouses because of an exception that speaks to family status. And of course, once you get into family status, the courts go to pieces over this one, and they've had great trouble squaring same-sex couples and family status. and I've got an outline of that. And that's all I'm going to say about it. Finally, God, I'm almost on time. Finally, I have a late-breaking case that you may or may not have, but I'll give you the citation because it's not in the paper. It's called Vrend, I believe that's how you pronounce it, V-R-I-E-N-D. And GALA, that's the Gay and Lesbian Awareness Society of Edmonton, and Dignity Canada, versus, of course, Her Majesty the Queen. And this had to do with a challenge to the Alberta human rights legislation, and the Alberta Court of Queen's Bench said that the Alberta human rights legislation, which does not contain the phrase sexual orientation, breached the Charter, Section 15, in not containing the phrase sexual orientation. Therefore, the phrase sexual orientation must be read into the Alberta legislation. That case also contains the nice point that the court may take judicial notice that discrimination against homosexuals exists. The date of this decision, as I say, it's Alberta Court of Queen's Bench, and the date is the 12th of April, 1994. It's not cited in the article, but everything else I've talked about is. Just for a wind-up, I guess, we've had the late debacle in the legislature, which was discouraging to anybody who's interested in human rights. So we're back into litigation. We're going to be talking in the panel much more about litigation strategy, and I hope that discussion will be interesting to everybody. I guess for now, I'll let you get to your coffee, and if there are any questions, I'd be, of course, happy to answer any. Thank you.